Good afternoon, and thank you for joining us for an MP webinar covering leave laws, FLMLA, PFML, etc., and when they intersect and how to navigate. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and a deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Andrea DeMarco. Andrea's practice focuses on representing employers in all aspects of employment law, as well as advising clients on proper compliance with the law to mitigate liability. While litigating is a central component of Andrea's practice, she also advises clients on daily issues related to policies, personal matters, discrimination, harassment, retaliation, leave, wages, accommodation, and compliance. Andrea frequently lectures on employment-related topics, including leave, workplace harassment, wage and hour, employee handbooks, and other workplace practices. Hatfield Schwartz Law Group is a woman-owned law firm in northern New Jersey with a practice-centered labor and employment law. Founded by Stephanie C. Schwartz and Catherine V. Hatfield in 2020, the firm provides dedicated personal attention to each one of their valued clients. Hatfield Schwartz was created with the mission to focus on client issues and determine innovative solutions with an unparalleled level of quality. They develop proactive business solutions, assisting their clients with all of their legal needs. For more information, including how to contact them, please visit www.hatfieldschwartzlaw.com. And just a few quick housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today, along with those presentation slides. So with all of that, I'm going to hand the mic off to Andrea.
Good afternoon, everyone, and thank you for joining me today. As Katie said, if you have any questions, feel free to put them in the chat, and I will review them throughout the presentation, but likely just answer at the end of our presentation. If we don't get to any questions, I will try to contact you after this presentation and answer them directly with you. So we are here today to talk about leave laws. So we'll go over FMLA and we'll address some laws in other states, as well as your sick leave laws, touch upon disability, and discuss the nuances of those laws and how they interact with each other. We'll talk about employer policies, what's important for you to have in place, and then we will have a little Q&A. So some of the topics that we will review today and which you want to keep in mind and make sure you understand with these leave laws is whether you are a covered employer or a covered entity, that is whether you have to comply with the law. If you do have to comply with the law, is your employee that's seeking leave eligible for leave under that specific law? How much leave is the employee entitled to? The various ways that an employee can take or utilize this leave. Notice requirements, so employer and employee notice requirements, proper designation of leave, wage benefits or supplemental wage benefits that the employee may be entitled to, and otherwise how the employee may be paid while they are on leave, any written policies or procedures that you either are required to have in place or should have in place, and then of course the interaction between these various leave laws and taking into account all the above consideration and how they interplay with each other. We'll also touch upon remote employees and how that may impact leave. So to start, we'll again discuss FMLA and then sort of how you need to be cognizant of what requirements you should be looking for in state laws. So FMLA, as I'm sure most of you know, is a federal law. It is the Federal Family and Medical Leave Act, and in a nutshell, it requires covered employers to provide employees with up to 12 weeks of unpaid job-protected leave per 12 months for certain qualifying reasons. So the key there is job protection. So what that means is that you are required to not necessarily hold the employee's position, but to return the employee to an equivalent position when they have exhausted their leave or when they return from leave. So an equivalent position means a position that offers similar pay, similar benefits, and similar terms and conditions. You also have to maintain health benefits during the time that they are on leave. So while the leave is not paid leave, you do have to maintain the employee's health benefits during that time. And if the employee does not return from leave, then they generally have to reimburse the employee for any premiums that were paid by the employer during the time that they were on leave. However, that is not a black and white rule. So there, of course, are nuances, and like anything, it is fact-based. So just a little bit of that information. So covered employers, who is a covered employer under FMLA? Covered employer is any private entity who has 50 or more employees, public entities or public agencies, and public and private elementary and secondary schools. So something to be cognizant of is state leave laws. So you want to make sure that you are looking at state leave laws in whatever state that you are located in, and potentially the state that your employees may be working from if you have remote employees, and we'll touch upon that a little bit later. So things you want to consider is that even if you do not fall under this list as a covered employer for FMLA purposes, you may fall under a covered employer under your state leave laws where your facility or whether you as an employer are located. So for example, I know in New Jersey, employers that have 30 or more employees are required to comply with New Jersey's family leave law. So even though an employer may not reach the threshold for complying with FMLA, they may have to comply with the state law. Alternatively, if you do have over 50 employees, you may have to comply with both FMLA and with state leave laws. And again, we'll discuss the interaction between those laws. So assuming that you are a covered employer under the FMLA, and that means you do have to offer FMLA leave to your employees, that doesn't necessarily mean that all employees will be eligible to take FMLA leave or to take leave under state laws. So to be eligible for FMLA leave, the employee has to meet all of the following criteria. They have to have worked for the employer for at least 12 months. They have to have worked for the employer for at least 1,250 hours over the past 12 months. And they have to work at a work site where the employer or company employs 50 or more employees within a 75-mile radius. And some questions that come up are, how do you determine the 1,250 hours? So that is determined by the FLSA. Those standards are determined under FLSA, and you'll want to look at that. And again, you want to think about state leave laws. So if an employee is not eligible for FMLA leave, they may be eligible for leave under your state leave law, again, depending if you are a covered employer under that law and depending on what your state leave law says. So again, I'm going to use New Jersey as an example because I'm familiar with it. In New Jersey, to be eligible, the employee only has to have worked 1,000 hours over the past 12 months rather than 1,250 hours. So perhaps the employee doesn't meet the standard under FMLA, but they may meet the standard under the New Jersey family leave law, and therefore that leave will have to be provided to the employee. So it's important that you understand that just because you may or may not be covered under FMLA, or the employee may or may not meet eligibility criteria under state leave, under FMLA, they may meet it under state leave law. And again, we'll talk about the interaction between these laws later on in the presentation. So determining eligibility, and again, going back to whether the employee is eligible or not, touching upon remote work. For purposes of determining eligibility, an employee's home is not a work site. So if the employer is located in one state and the employee works full-time from another state, their home is not what is considered a work site. An employee's work site is the office to which they report to and from, and which assignments are made. So an example, an accountant works remotely full-time from home in California, reporting to an office in New York, where her firm employs 150 employees. 100 of those employees work in the New York office. So the New York office is a covered employee under FMLA and would be required to provide FMLA leave to their eligible employees. So here, even though the accountant works more than 75 miles away from the office in New York, she's eligible for FMLA because the New York office is what's considered the work site under FMLA, not her home. So about the types of leave that can be taken under FMLA, you have intermittent and continuous leave. So continuous leave means that the employee can take up to 12 weeks of consecutive continuous leave in the 12-month period. Intermittent leave or reduced leave means that they are taking it not continuously. So intermittent leave means that they're probably taking it in blocks. So perhaps they're taking it for 2 weeks and then they're coming back for 2 weeks and then they're taking another 2 weeks, or they're taking it in days. So they're taking it every Monday and Tuesday of every week for X amount of time. Under FMLA, the employees are eligible for up to 56 days of leave in a 12-month period. And reduced leave means that they are taking it in a reduced leave schedule. So perhaps they need to come in late every Tuesday and Thursday because they are going for medical treatment in the morning and they can't report to the office until 11 a.m. So that would be a reduced leave schedule. And again, state laws, if the employee is eligible for leave under state law and the reason qualifies for leave under both state law and FMLA, and we'll talk a little bit more about this, you want to make sure that you're familiar with what the state law says. So under the state law, can the employee also take intermittent or reduced leave? Can they only take continuous leave? And those are things you want to consider. What supersedes? Generally, federal law will supersede. So if your state law says that employees can only take continuous leave, but FMLA, as we know, says they can take continuous, intermittent, or reduced leave, and the employee is taking leave for a reason that qualifies under both FMLA and the state leave law, FMLA federal law will supersede. So they will be able to take that intermittent or reduced leave if they need to. There's some additional nuances to that under the law that I'm not going to get into today for purposes of this presentation. And again, it's always a fact-based consideration, but generally that is what your law says. So what about notice requirements? There are certain requirements under the law that fall on the burden of the employer and the employee. So generally speaking, you do have to place all your employees on notice that they have leave rights if you are a covered employer under FMLA. So if you're required to provide employees with leave under FMLA, there is a workplace poster that is required to be posted in the workspace in a place that is noticeable and conspicuous. And those posters are available on the Department of Labor website. So you can pull them, you can print them out, and you can laminate them and post them in your work site so that employees are on notice. We also always recommend that if you are a covered employer, that you also have a comprehensive policy in your employee handbook that puts employees on notice that they are entitled to leave and what their rights are under these laws. In terms of providing notice to employees when they are seeking leave, generally, an employer has an obligation to provide employees with a response to their FMLA request within 5 days of the date that that request was made. In addition, there are certain requirements under the law that says the details of the notice that have to be required. So the employer must notify the employee not only that their leave is granted, but they should be including the dates of leave. So this is the day that the employee is commencing their leave. This is the day that they are expected to return. That date may change throughout the time that the employee is on leave. However, for purposes of initial request, it should stipulate when the leave starts and when the employee is anticipating returning. You want to indicate whether the employer will require the use of paid leave. And we'll talk a little bit more about this later in the presentation, but you may have a policy in place that says that employees are required to use paid leave first. So they're required to use PTO or sick leave prior to commencing the unpaid portion of their leave. If that is a policy that you have in place, that should be in the notice so that the employee is aware that they are required to use this PTO time or this sick time while they are on leave. You also want to list any conditions related to the use of the accrued leave, if there's any other conditions, and you want to put the employee on notice that their position will be available for them when they return, or that an equivalent position will be available for them when they return on leave. If you as an employer are not able to hold the employee's exact position open while they are on leave, you must notify them this at the time that they take leave. And this is very important because if you don't notify them that you may not be able to hold the position open, then they can absolutely bring a legal claim against you at a later point, seeking a violation or stating a violation of FMLA and seeking to return to that exact position. So again, you are required to return them to an equivalent position, but not the exact position that they are in at the time that they take leave. However, if you cannot return them to that position, you need to place them on notice at the time that they take leave. So requirements for employees. So generally, an employee should provide the employer with at least 30 days notice that they are seeking leave if the leave is foreseeable. Of course, there's going to be times where someone gets in an accident or where a family member gets in an accident or injured or is sick and the leave is emergent and not foreseeable. That's not the same situation. However, at any time the leave is foreseeable, so if there is a pre-scheduled surgery, if someone is going out on leave for giving birth, generally the date is foreseeable, or at least an anticipated date is foreseeable, they are required to provide you as the employer with 30 days advance notice of that leave. An employee also has an obligation to respond to any of your questions to determine whether the absence is FMLA qualifying or not. They are required to fill out certain paperwork, certain FMLA forms, return them to you as the employer so that you can review them, ensure that this is a qualifying reason, and designate the leave properly. When the approximate timing of leave is unforeseeable, again, the employee must provide as much notice as possible. So what are some reasons for FMLA leave? An eligible employee can take FMLA leave for any of the following reasons: the birth and care of the employee's newborn child, the placement of a child with the employee for adoption or foster care, an inability to work due to the employee's own serious health condition, an inability to work due to the need to care for a family member with a serious health condition, or, excuse me, any qualifying exigent arising out of the employee's immediate family member being on active duty or called to active duty. And again, we'll discuss the interactions with state law for reasons for leave. So many questions that we get is, what is a family member? Right now, a family member is defined as a spouse, a child, or a parent. A serious health condition under FMLA is defined as an illness, injury, impairment, or physical or mental condition that involves either inpatient care or continuing treatment by a healthcare provider. Both physical and mental conditions qualify as FMLA leave, so please keep that in mind, as though we see that often that someone is seeking leave because they are dealing with mental health issues. And again, this definition is somewhat vague, somewhat ambiguous. As always, it is determined on a case-by-case basis, but generally, more often than not, when someone is seeking leave for a health condition, it will fall under a reason qualified under FMLA. You as the employer also are permitted to ask for medical certification, and we usually recommend our clients do that. That says that they need to take leave, and this is the reason why. There are certain nuances and laws that say how much you can ask or how much detail can be in those notices, but you as the employer are entitled to ask for certification that says that this employee has been advised by a doctor that they need to be on leave or that they cannot work because of this condition. Excuse me, a little cough today. So interactions with state laws, some things that you want to consider is with any sort of state leave or medical law or other types of family leave, medical leave, sick leave, paid leave laws, and we'll discuss some of them a little bit later in the presentation. You want to make sure that you understand the nuances of each law. So these laws are pretty basic in general, right? FMLA says that generally you have to provide an employee with up to 12 weeks of job protected paid leave in a 12-month period. Okay, that's simple. It's all the nuances. What are qualifying reasons? What type of notice has to be given? What is considered a reason? We know what the 5 reasons are. However, again, does the employee qualify as someone with a serious health condition if they're seeking leave for a family member? Does their family member qualify as a family member under the law? Is the family member's condition or illness a serious health condition under the law? What type of notice do you have to give? What type of notice do they have to give? That's all these little nuances that you need to understand and be aware of to ensure that you're not only complying with FMLA law, but that you're complying with any state laws and that you are understanding the interaction and interplay between these laws. So things to consider that often come up is how much time has to be given to an employee. So if a reason that the employee is taking leave is a qualifying reason under both the FMLA and your state law, you need to understand whether that will run consecutively or whether it runs concurrently, so you know how much time the employee is or is not entitled to, and in what type of period. So in FMLA, we know it's 12 weeks in a 12-month period. What does your state law say? Is it 12 weeks? Is it more than 12 weeks? Is it in a 12-month period? Is it in a 24-month period? You need to make sure that you understand these things so you can understand how the law is run and how much time an employee is entitled to and how you're designated that leave. You want to understand if employees are entitled to job protected leave or just leave, whether the leave is paid or unpaid, the type of notice that has to be given, the type of notice that they as the employee have to give to you, and when the leave will replenish. So something to keep in mind is that nothing in FMLA will supersede any provision of state law that provides greater family or medical leave rights than those provided under FMLA. So while FMLA as federal law will always supersede state law, that doesn't mean that the state laws can't have actually greater protections. In states that do not have their own laws for taking family or medical leave, there can be a daunting number of ways that state and federal laws stack up against employees. And typically the main questions relating to how these type of leave laws interact, and as we touched upon, involve the total amount of leave that an employee can take off, which includes reasons for leave and available time, notice requirements imposed on employees and employers, and any certification requirements with respect to leave. So some interactions that we see between FMLA and state laws that often come up, or whether, like I said, whether the leave qualifies from FMLA leave and leave under a state law, is the leave is generally counted against the employee's entitlement under both laws, and the leave will generally run consecutively. So, for example, we know under FMLA that an employee can take leave for their own serious health condition. So if an employee is taking leave for a reason that qualifies as a serious health condition under the FMLA, and you are in a state and your state law also allows employees to take leave for their own care for a serious health condition, and the definition of serious health condition is a reason that the employee qualifies for under both state and FMLA, then you need to determine, will that leave run consecutively? If they are taking a leave for a reason that qualifies under both state and FMLA, then most likely it is going to run consecutively, meaning that if they have up to 12 weeks available under FMLA and up to 12 weeks available under state law, they are getting a max amount of 12 weeks. However, it's not always that simple, as we know. So, for example, let's say that an employee is seeking leave for the birth of a child. So we know under FMLA, the employee can take leave not only for their own serious health condition and to care for themselves, but for bonding with that child. If you have a state law, and I'm going to use New Jersey as an example again, because I'm familiar with New Jersey. So in New Jersey, an employee cannot take leave under the New Jersey state family medical leave law for their own serious health condition. However, they can take leave to bond with a newborn child. So if there's an employee who is giving birth and she's seeking leave, she could be entitled to a various amount or an extended amount of leave, because she can be entitled to leave for her own serious health condition, for recovering from the child's birth, and then can be entitled to leave for bonding with the child. And that leave will not necessarily run concurrently, it will run consecutively. So, for example, try to break this down in numbers off the top of my head. Let's say that the employee can take 12 weeks, we know, in total under FMLA, and the employee has up to 12 weeks total under the state law for bonding time. So let's say she gives birth, and after the birth, she needs 6 weeks to recover from that birth. So she can take 6 weeks of time that will be solely designated under FMLA as time to care for herself, time to care for her own serious health condition to recover from that birth. After she's exhausted that 6 weeks under FMLA, we know she has a remaining 6 weeks to use under FMLA for any reason that qualifies under FMLA. So now she wants to take time to bond with her child. So she has 6 weeks of leave left under FMLA to bond with the child. However, she also has 12 weeks of leave under the New Jersey state law to bond with the child, because New Jersey state law does not allow employees to take time off for their serious health conditions. So none of the 6 weeks that she has taken has counted against her entitlement under state law. So she can take 6 weeks of leave for recovery, and then she still has an additional 12 weeks of leave that she can take for bonding time under state law, for a total, as we know, of about 20 weeks of leave. And as an employer, you are not only responsible for being aware of this and for recognizing this and for understanding how much leave an employee can be entitled to, but for properly designating it. So you want to make sure that your employees are filling out the proper forms, so FMLA forms as well as any state leave forms. And you want to make sure that you as the employer are designating and keeping track of the leave properly. So how much leave have they exhausted under FMLA? How much leave have they exhausted under state leave law? Do they have any leave entitlement left under either of these laws? Okay, in addition to understanding the type of leave that they may be entitled to and how much leave they are entitled to, you want to make sure that you understand what type of wage benefits that they may be entitled to. You may, as the employer, be able to require them to utilize accrued PTO or accrued sick leave during the time that they are on leave. The purpose of this is so that, let's say an employee goes on leave for 12 weeks under FMLA, and then they return and they still have another 6 weeks of vacation available under your employer's policy, and they still have another 5 weeks of sick leave, and then they take that, and now this employee has been absent for half the year. So the policy behind FMLA is that you can require employees generally, for most reasons, to use their accrued PTO and potentially accrued sick time while they are on leave, so that when they come back from leave, they don't now still have all this PTO and vacation and sick time available to them. They have now exhausted that as well. However, if the leave is paid, they are entitled to pay during that time that they are on leave. If they are not required to use any sort of accrued paid time off, some states will provide supplemental wage benefits to an employee when they're on leave. This is not available in all states. I know it's available in New Jersey. It's available in California. I believe New York has it. And there's a handful of other states that do offer it, but surprisingly, many states actually don't offer these benefits. However, if your state does offer it, you as the employer should be aware of this, and you should know what an employee is generally entitled to, so that you can provide this information to your employees and guide them correctly. In most states, it is up to the employee to actually file that request for benefits through the state. It is out of your hands at that point, but you should still be aware of what the laws are, what they say, what an employee may or may not be entitled to. So what about sick leave, PTO, and other leave? So some states maintain sick leave laws that require employers to provide a minimum number of paid or unpaid sick days to employees for qualifying reasons. So it's important to understand this as well, because again, this could overlap with any state leave laws or with FMLA. So if an employee is taking sick leave or is taking leave for a reason that qualifies or is designated under both FMLA and your sick leave law, will that run consecutively or will it run concurrently? So you'll need to make sure that you're familiar with your state leave laws to see what that says and whether those are separate leaves or whether they will be counted against each other and run concurrently. Also, some laws or some states allow you as the employer to choose this. So you may be able to require those leaves to run concurrently, or you may permit your employees to use them consecutively. Are employees required to substitute PTO by taking FMLA? Again, generally under FMLA, you as the employer are permitted to require your employees to use PTO leave during any time that they are also on FMLA designated leave. However, you have to have a policy in place that states this, because employees need to be aware that this is a requirement prior to them taking FMLA leave. It is not mandatory. Generally, it's just allowed under FMLA law. So it is up to you as the employer to decide whether this is something that you want to put into place and to make sure that you have the proper policy in place that says this. Again, there's certain nuances to that may not qualify for every single reason under FMLA, but most reasons it can be taken. And again, you want to look at your state laws to say if your state law permits it, because if the state law says that employers are not allowed to require their employees to use paid time off, you need to be aware of that, because you need to make sure that, again, if it is a reason that falls, if the employee is taking leave for a reason that falls under FMLA and state leave laws, what's going to supersede? Can you still require them to substitute their leave with PTO, or is this not going to be permissible because it conflicts with state leave law? So remote employees, something that now employers are facing, and that's becoming a bit of a challenge, is understanding what laws the employer needs to comply with when you have employees that are working full-time in a state that is outside of the state the employer is located in. So you need to understand, and again, we touched upon this with FMLA, we know that for purposes of determining a work site and determining eligibility, the work site is where the employer is located. It is not where the employee is working from. You need to look at your state leave laws. Most laws have not caught up with current times, have not been addressed or not been changed, modified to address that employees are working remotely, and that it is absolutely common for employees to be working remotely and to be on this hybrid schedule. So you will have to look at laws, and you may have to consult with your attorney or with an attorney to determine what is appropriate and what laws you need to comply with. A general rule of thumb is that usually state and local laws of the physical location where the employee is working will govern. So for example, New York State says paid family leave is a benefit for people who work in New York State. Does not matter where the employer is headquartered or where the employee lives. If one or more of your employees in employment in New York State for 30 or more days in a calendar year are employed, in New York State for 30 or more days in a calendar year, you must obtain disability and paid family leave coverage for those employees. So again, you want to make sure that you are familiar with the laws that are in the state where you're physically located, as well as the laws where your employees are working from, to determine whether you have to comply with the laws of the state you're located in, the laws the employer is the employee is working from, or both. And some policy considerations for employers are, some state laws will specify that if a handbook or policy is silent on a certain issue pertaining to leave, then it will default to whatever the state law says. So it may default to payment and leave that has to be implemented. So you want to make sure that you're understanding the laws of the state that you are located in, to know what sort of posters you have to have in place, what sort of requirements, notice requirements you have to advise your employees of what their rights are under the law, and any sort of other policies that you have to have in place that state, how employees will be paid, whether they can or cannot use or substitute PTO or sick time for times that they are on FMLA leave or other state designated leave, how you have to pay them, any sort of notice requirements. Just want to make sure that you are fully familiar with the laws of your state, not just FMLA laws, to understand what written policies that you have to have in place. So other just best practices are including, and again, I said this in the beginning of our presentation, if you are a covered employer under FMLA or under your state law, we always recommend including in your employee handbook a full description of what the law says and what the employee's rights are, as well as what their obligations are. If you don't have it in place in writing, how are the employees supposed to know what their obligations are and what their rights are under the law? You should definitely have a policy for reporting leave, and it should be consistently applied. All supervisors and managers, we always recommend ensuring that they are trained so that if employees ask them questions or come to them or even tell them that they need to take leave, the supervisor knows how to handle it, knows what to do, knows who else to report it to go to HR, to go to whoever is above them. If paid leave is offered or required by state law, your policy should also specify how the state law interacts with FMLA. It's not only will help you as the employer because it's sort of a reference or a guide for you and you have that in place, it obviously helps the employee in understanding what the law says, what their obligations are, what their rights are, and more importantly, what their rights are not. Employees are so, as we know, many employees are litigious, and they will be more likely to challenge you as the employer or challenge their rights if they are not aware of them. So if you have a policy that is detailed and lays out what the law says and what the employee is and is not entitled to, you can help mitigate some of those challenges. And again, for remote employees, you want to designate who they are reporting to, what office or what person they're reporting to, and perhaps you want to clarify what their eligibility status is under FMLA leave law, under state law, and what laws or what states' laws they are or are not entitled to. So just a reminder is that you as an employer are prohibited from interfering or restraining with an employee's FMLA leave rights, and generally that will apply to any state leave laws as well. You cannot retaliate against someone for taking leave, and you generally cannot deny leave unless the employee is not entitled to leave under the law, unless they're not complying with some sort of other policy under the law or other mandatory requirement under the law. So as we touched upon, some of the posters and the forms that you as an employer can pull to use, that you not only should have either hanging in your workplace to put employees on notice of their rights, but also forms that you can use for designating leave are available on the DOL's website. And some of the forms are listed here. You can go to the DOL's website, pull them right there, download them, hang them, use them in your HR room, use them to give out to your employees, and to make sure that you are properly documenting and designating leave properly and accordingly. Okay, so that is all I have for you today. I think some of the takeaways today are just making sure that you understand what laws that you as an employer are required to comply with. So everybody knows FMLA exists and knows about FMLA law, but you want to make sure that you understand that there are state leave laws as well beyond just FMLA, and that you are aware of those laws and aware of whether you are a covered employee, or meaning whether you have to comply with them or not, what the nuances of those laws are, and how those laws may interact with each other. So how FMLA interacts with state leave laws, how it interacts with sick leave laws, with PTO, with disability, with other sort of leave and payment laws that are in place. So you know that you're properly compliant with the laws, you're designating the laws correctly, or you're designating employee leave correctly, employees are being paid correctly, they are retaining their benefits when they need to be or not need to be, and that you are not violating any of the laws. Okay, so I will look at some of the questions that we have. So under FMLA, how is the 12-month period calculated? So you have to provide employees with 12 weeks of leave in a 12-month period. You as the employer are able to decide what that 12-month period is. And again, we recommend putting that in any written policy you have. So you can use the calendar year, you can use an employee's anniversary year, or you can use a look back or rolling period. We generally recommend that. It seems to be the easiest. It means that it is measured backwards from the time that the employee takes leave. So if the employee took leave a year ago and they're now looking to take leave again, you can use that as a look back period to determine whether a full 12 months has passed or not. If an employer fails to notify the employee that the leave has been designated at the time that they take leave under FMLA, can it be retroactively designated? So generally the answer to this is no, which is why it is important to make sure that you understand the leave laws up front, and that you are providing your employees with proper forms, and that they are filling out the forms, completely filling out the forms, and that you as the employer are intaking those forms and then providing them with written notice of leave, what they are entitled to and how much time they are entitled to. Because if the employee goes out on leave and then 6 months later you realize that leave actually was a reason that qualified under FMLA, you cannot retroactively designate it as FMLA leave law. So if they used PTO time or vacation time and you did not want them to, you want it to be counted as FMLA leave now, you can't go back and count that against their general leave entitlement. Of course, again, this is not a black and white answer. There may be times where you might be able to go back and retroactively change it or designate it if, for example, the employee failed to provide you with notice or failed to tell you with the true reason that they were taking leave. Then you may be able to go back and change it or designate it retroactively, but generally the answer is no. You cannot retroactively designate it as FMLA leave. It has to be designated at the time that it is taken. So is notice of eligibility provided 5 days after they first ask for FMLA leave or when they actually submit their paperwork? So as soon as they ask for leave, you should be providing them with the forms immediately, and then it is counted 5 days after that. So once they return the form, you at that time have 5 days to tell them whether or not this leave qualifies as FMLA leave, that you're granting it, and that they are going to be taking FMLA leave for X amount of time, and any other nuances or requirements, conditions that you want to put in that notice. This also applies to medical certification. So if you as the employer are asking them to provide you with medical certification, that time period sort of stops or is delayed until they provide you with a proper certification. So if it takes them 10 days to get back to you, the clock does not start until that 10-day period ends. With intermittent leave, does any increment of time missed from work on a given day count as one of the 56 days? I'm not entirely sure I understand the question, but if you mean increment of time as in an hour or a half hour, that would probably count as reduced leave, not intermittent leave, because if they are only coming into work an hour a day, generally you're not discounting their entire day. However, under the regulations, FMLA does state that you are only required to allow an employee to take reduced leave in the max amount or minimum amount that is in compliance with your other laws. So for example, or your other policies, I'm sorry. So for example, if you have a sick leave policy in place that says that employees can take sick leave up to half-day increments and the employee needs to come in late for work, then yes, you can count that as half a day, but you would not be able to count it as a full day of leave. But I'm not sure if I'm answering your question correctly, because I'm not sure I understood it correctly. And again, it is sort of a case-by-case factual basis, depending on what your policies say, what leave they are taking, what state laws may be in place, and other considerations. Okay, there are a few other questions here that I would like to look into a bit before I respond to them. So I can reach out to those of you that have asked directly and back to you with answers. And if anyone else has questions, feel free to submit them.
Great, thanks.
So, go ahead.
No, I was just going to close us out. Did you have any closing statements?
I was just reading another question. No, thank you all for your time today.
Great, thank you so much, Andrea. To learn more about NP's full service solutions for 2023 and more, and understanding those leave laws, you can visit us on our website at nphr.com. For more information, you can also visit Hatfield Short online at their website to learn more, to get more information. Be sure to join us next week for our upcoming webinar on ADA accommodation requests, essential guidance for every employer. Visit our website to register and see the full calendar of upcoming events and available resources. We will be sending out the recording of today's webinar along with the presentation slides this afternoon. Thanks for joining us and have a terrific day.